A father's will says that everything should be divided equally among his 3 children. That sounds clear. But his retirement account names only one child. His savings account has a payable-on-death beneficiary, and the deed to his home includes another owner. Which instruction controls? The answer usually depends on the asset. A will is important, but it does not automatically override every beneficiary form, account registration, ownership title, deed, or trust. For an adult child, this matters because a family can read a will correctly and still misunderstand how a parent's property will pass. This video will help you recognize what may control each asset and identify the questions that still need answers. The clearest place to begin is not who is named in the will. Begin with what is the asset and how is it legally owned? An account held in one person's name with no beneficiary designation may enter the probate estate and pass under a will. Another asset may be controlled by a contract or its title. A parent might have an individual checking account, a life insurance policy naming 2 beneficiaries, a retirement account naming 1 beneficiary, and a home with survivorship rights. Those assets may follow different paths even if the will calls for equal shares. That does not automatically mean the plan is wrong. A parent may have chosen different recipients for different reasons. The point is that the result for one asset cannot be assumed from the instructions for another. Ask, who owns this asset now? Is a beneficiary listed? Is there a surviving co-owner? Is it held in a trust? And what record does the institution or title office recognize? Some assets commonly pass through beneficiary designations. These can include life insurance, individual retirement accounts, many workplace retirement plans, annuities, and certain employee benefits. The designation accepted by the insurer or plan administrator generally controls that benefit. A later will does not usually replace an earlier beneficiary form. Suppose a mother's will leaves her estate equally to her children, but an older individual retirement account still names only her oldest child. The family may believe the will changed the account. In many cases, it did not. The executor also may not have authority to divide that account differently. The company will usually follow the valid designation and its plan or contract rules. There are important exceptions. Many employer-sponsored retirement plans give a surviving spouse particular rights. Depending on the plan, naming someone else may require the spouse's written consent. Individual retirement accounts do not always follow the same rules as workplace plans. Ask the company who is listed as the primary beneficiary and whether a contingent beneficiary is named. Confirm any percentages, spousal consent requirements, and what happens if no valid beneficiary remains. The tax consequences are separate. Inheriting a retirement account can create distribution and income tax responsibilities that the will does not explain. Bank and investment accounts may also contain instructions that operate outside a will. A payable-on-death designation is often used with a bank or credit union account. A transfer-on-death registration is often used with a brokerage account or securities. The owner names a recipient for the asset after death. During the owner's lifetime, that person is generally not a co-owner merely because they are the future beneficiary. They normally cannot withdraw funds or manage the account based on that designation alone. After death, the institution may require identification, a certified death certificate, tax information, and claim forms. One misunderstanding is that an unsigned note, a family spreadsheet, or an unprocessed form will change the institution's records. It may show intent, but the institution will generally look to the designation it accepted. A useful question is not only, who did you intend to name? It is also, can the institution confirm what is currently on file? Ask what happens if a beneficiary dies first and whether contingent beneficiaries are allowed. If terms such as per stirpes appear, ask the institution or attorney how that wording will be applied rather than guessing. Joint ownership is different from naming a beneficiary. A beneficiary usually receives an interest after the owner's death. A joint owner may receive legal rights while both people are alive. In many joint bank accounts, either owner may be able to withdraw funds or close the account. A real estate co-owner may have rights affecting a sale, refinancing, creditors, or later transfers. The word joint does not fully explain what happens at death. Some arrangements include a right of survivorship, meaning the surviving owner generally receives the deceased owner's interest. A tenancy in common usually does not. The deceased owner's share may instead pass through a will or under state law. Consider a parent who adds one daughter to a checking account so she can pay household bills. The family thinks she is only a helper, but if the account includes survivorship rights, the balance may pass to her rather than being divided under the will. The bank should be asked exactly what rights were created. Is the person a joint owner, an authorized signer, an agent under a power of attorney, or something else? Can either person withdraw all the money? Does the account include survivorship rights? The answer depends on the agreement and state law, not family memory. A trust adds another possible layer. Signing a trust document does not automatically place every asset into it. The asset generally must be legally connected to the trust. A home may need to be deeded to the trustee. An account may need to be retitled. Another asset may name the trust as beneficiary when that is appropriate. Suppose a parent transfers a home into a revocable living trust, but leaves a brokerage account individually owned with no transfer on death registration. The trust may control the home while the account follows another process. This connection is often called trust funding. It means transferring or assigning property so the trust actually owns or controls it. A pour-over will may direct certain probate property into a trust after death, but that does not necessarily avoid probate for property that was never transferred to the trust during life. Ask whether the asset is titled in the trust's exact legal name, whether the trust is the owner or only a beneficiary, and whether any deed was properly recorded. Naming a trust as a retirement beneficiary can create legal and tax consequences, so professionals familiar with both areas should review that decision. Real estate is often controlled by the deed, together with state law. A home might be individually owned, jointly owned with survivorship rights, held as tenants in common, owned under a spousal form, or held in trust. Some states also permit transfer on death deeds. Because these arrangements are not interchangeable, the recorded deed matters. Suppose a will leaves a house equally to two children, but the deed names the parent and one child as joint owners with right of survivorship. The deed may cause the property to pass to the surviving owner instead of under the will. The exact result depends on whether the deed was valid, how state law interprets it, and whether marital or other rights apply. A transfer on death deed has formal requirements. Where permitted, it generally must be prepared, signed, and recorded correctly before the owner dies. A will should not be assumed to create, revise, or cancel it. Transferring a home does not erase mortgages, liens, other claims, insurance concerns, or title defects. A qualified professional may need to answer: what ownership form does the deed create? Are there survivorship rights? Does this state recognize transfer on death deeds? Was the document recorded correctly? And does property in another state follow different rules? Problems often appear when records were created at different times. An ex-spouse may still be named on a policy. A beneficiary may have died. A trust name may be incomplete. Percentages may not total 100%. A minor or someone receiving needs-based public benefits may be named directly. A child may have been added as a joint owner for convenience, even though the parent expected the money to be shared later. No single rule resolves every situation. If a beneficiary designation fails, a contingent beneficiary may receive the asset. The contract may name a default recipient. The property may become payable to the estate. Federal law, state law, a divorce order, or institutional rules may change the result. It is also important to separate probate from other questions. An asset can pass outside probate and still be relevant to taxes, creditor claims, a mortgage, Medicaid recovery, spousal rights, or a dispute involving capacity, fraud, or undue influence. So, avoids probate does not mean avoids every obligation. When records seem inconsistent, identify the specific conflict. Does the will name one person while the policy names another? Does the family's copy differ from the institution's record? Does a trust refer to property still titled individually? Those focused questions give the appropriate professional something specific to evaluate. For trustworthy general information, you can begin with resources from the American Bar Association, the United States Department of Labor, the Internal Revenue Service, the Securities and Exchange Commission's investor.gov website, the Consumer Financial Protection Bureau, the Federal Deposit Insurance Corporation, state courts, and recognized legal aid organizations. Direct links are included in the description so you can continue your research using these original sources. This video provides general education, not personalized legal, tax, financial, or insurance advice. The exact answer can depend on state law, document wording, account agreements, insurance contracts, retirement plan terms, deeds, and individual circumstances. The main lesson is simple. Do not ask only what the will says. Ask what legally controls each particular asset. Sometimes the answer will be the will. Sometimes it will be a beneficiary form, account registration, ownership title, deed, or trust. Understanding that difference can help a family ask better questions while respecting the parent's right to make their own choices. Consider whether there is a family asset whose transfer method is still unclear. You can review the trustworthy resources in the description to help identify the questions that may need to be answered. If you have a general question, an additional suggestion, or another reliable resource that could contribute to this discussion, please share it in the comments. Your input may help another viewer recognize something they still need to clarify. A will is one important part of an estate plan. The goal is to understand which legal instruction applies to each asset.